Sir, can you state your name?
Me, Devin Gibson.
All right. All right. What are we doing? You're requesting an adjournment?
Yes, ma'am.
Probable cause conference will be adjourned. It's 2 weeks up, the 10th. April 10th. Will that work for you, Council?
That'll work.
April 10th, 2025, 9 a.m. As your invite indicates, bond will continue.
Commission to address bond.
Go ahead.
18-year-old lifelong resident. He is spoken to presumption and innocence in this matter. He do have his father here who support him, so he has significant community ties. He understands that there's going to be no contact between the witness and respectfully honored. My client indicates to us that even if she needs to tether,
Go ahead. You know what I'm saying?
we respectfully request the personal boundary tether, or at least to lower it.
Response.
Thank you, Your Honor. First, I want to ask if the court has a copy of the prosecutor's bond recommendation from its file.
I do.
I wanted to ask if the court would go to that. You will see that the authorizing APA on this case originally requested a cash or financial bond of $500,000 cash surety. I believe that what was actually ordered was significantly reduced amount, if I'm not mistaken, of $50,000 with a 10% privilege on top of that. I think the recommendation form will get into detail about some of the concerns on this case. There is a GPA charge, and there is apparently a very bloody scene in this residence, including several counts of RNO with damage to a police vehicle and an ethnic intimidation charge as well. We're very concerned about the safety of the victim and the community in general. So the people would ask that the significantly reduced bond was originally requested.
Anything additional, Council? Motion for bond reduction is denied. Bond will continue. Thank you.
That's it, correct.
Court calls case.
That girl, when she put her hands on me, though.
Oh. Do we need it to go back up? Okay, no. Leave it alone? Okay. You're a nicer person than me. Court calls. All right. Record should reflect we've had a brief bench conference in this case. All right.
Yes, Your Honor, we'd like to set this matter for a
Preliminary. All discoveries complete, Council.
all discovery.
All right. And is it the 8th? Yeah. And would the people have their witnesses available the 8th?
We'll do our best, Your Honor.
All right. Preliminary examination in person, April 8th, 2025, 9 a.m. That's before Judge Valvo. Bond, go ahead. You want to address bond?
You were about to say, respectfully, my client's been in jail roughly a little bit over 2 weeks now. I do understand that you have previous actions with my client. Reached out over the phone, but he understands the consequences of those actions at this moment. Respectfully, his phone privilege is revoked right now. He does have a lot of business that he needs to attend to, at least to sort of keep his life going. He's closely presumption of innocence at the moment, and if he is found to be innocent, then his life will be impacted significantly by him sitting in jail, or at least not being able to make any phone calls to handle the jail. I do understand these are serious assaultive allegations, but my client is ready to face those allegations, maintaining his innocence in this matter, and respectfully, Your Honor, we're asking the dishonorable court give my client a chance, even if it's with the GPS tether, or even if we at least become more lenient on his phone call, so that he's able to keep his life in some sort of balance while he's locked up.
Response.
Will judge any modification of bond. As the court heard, he had previous jail calls that weren't addressed that were to the victim after he had been arraigned. He also has numerous dismissed DV cases. He has a detective DV from 2021 on another dismissed from firearms and DV cases. And in these cases, there is at least 4 instances of him terrorizing the victim in which he is throwing things around the house, taking her phone, pushing her against the couch, taking her phone again, pushing her on her chest, grabbing her wrist, pushing her around the house, taking her phone again, throwing her down on her stomach, stomping on her back, grabbing her by her hair, slamming her to the floor, and choking her. So I have extreme concerns for her safety and would object to any modification of violence.
That's allegedly, that's allegedly. My client has proven that performed those actions against that person. And I ask you, please don't use domestic violence cases against my client, or at least assume that he's guilty or that he had something to do with those cases, because if we want to make assumptions, we could assume that somebody may be lying on him and trying to use the police against him because of what they might be going through in their relationship that's not assault of marriage. So, respectfully, Your Honor, we're looking at this case on its face. I do understand the assault of nature. I do understand we have that phone call. But my client got his phone call revoked, not able to speak to anybody, been sitting in jail over 2 weeks. He understands the severity of those.
Yeah, but that's by his own due. I mean, it's not as though we just decided to sort of hold him incommunicado. The problem is that he couldn't follow the conditions as we laid them out. So if I released him, what would make me think that he would follow any of the conditions that are set right now? He didn't do it before.
There's ways to mitigate that, Your Honor. There's ways to mitigate that from GPS test, even if it's house arrest. With a GPS test, if he steps out of that house, then he's going to be arrested.
Couldn't follow the conditions when we first gave him to him. Motion for bond reduction denied. Bond will continue. Thank you. Courthouse case, People versus Jacob Potter.
And I said on behalf of the people.
Yeah. Is that who they have?
My right. So you're playing for the record. Jacob Alexander Potter.
Thank you.
At this time, we're going to respectfully requesting the subject for a preliminary exam.
All discovery is complete.
My apologies.
People have their witnesses available the 8th.
We'll do our best, Your Honor.
Preliminary examination in person, April 8th, 2025, 9 a.m. That's before judge.
Address bond briefly.
You may.
My client is going to be asking for a PR bond. He has a place in Belleville where he's staying with a friend over on Rustic Drive. He's going to want to tether if the court deems that necessary. He just wants to get back to his job. He works at public disposal. So 50 hours a week there. He wants to get back to his job. So
Yes.
Your Honor, I was also going to ask the court to address bond, as he has made 52 calls to the victim from his pen since arraignment. In these calls, he says, "You got to go to the prosecutor's office and tell them it's not written down right, that I live there too. I damaged the door, they're making it look like I just entered the place, I've never been there before, and that I'm your ex-boyfriend." He also says, "Go to the prosecutor's office and speak on our behalf, whatever, I can't talk to you." He also says, "This is a serious issue. I don't know if you can help. I don't know the prosecutor tomorrow or anything. I don't know. You need to leave your number out of anything you may sign." You know what I mean? If you or the prosecutor or anything, leave your phone number out of anything that you might sign. That way they can't link you to my call history. And then he also asks her to get on the text now app they have in the jail because we can't see that. And that's why he wants to keep communicating with her. So I have extreme concerns that he can't follow court orders and reject any modification.
I understand your right. We spoke no contact. Understands that there needs no contact period. He just wanted to somehow give the information to the court that he lives at the address. But
He wanted to get that communicated to the person that does live at the address? That makes no sense.
I will just add that when he was at that address, he kicked the door open and entered the house without permission, and he began throwing her items against the wall and was intoxicated.
So I should be here. I think you can go ahead and hear that.
Defendant's phone privileges are revoked. Defendant's motion for bond reduction is denied. Bond will continue, but his privileges are revoked.
Understood, Your Honor.
Thank you. Court does call the cases of the People versus Beverly Boss. They need to sign off.
This is public defender deputy. Probably with and on behalf of Ms. Boss, who should be dialed into Zoom, Your Honor. She called the public defender's office this morning. She talked to several of the legal assistants. She's actually sick and she was having trouble logging onto Zoom, but I believe she was finally able to successfully dial in. If she's using her father's phone, the last three numbers would be 238.
Nope. I have one call in.
I'm
Could
not
they?
sure if that's the number she's using. If it's her father's phone, it would be that number.
Miss Boss, if you called in on Zoom, I only have one number, but if you called in on Zoom, you'll need to hit *6 on your phone to unmute.
Hello?
Oh, hello. What's your name?
Hello. Beverly Boss?
Oh, that's her.
Awesome, thank you.
Yes, that's me.
So, Your Honor, I have discussed this matter with people. I was planning, Ms. Boss and I have not been successful in having a phone conversation prior to today. I was going to give her an update this morning, person obviously was unable to be accomplished. I would ask her to tell me loud. I understand in 2 weeks.
It's going to be 2 weeks.
I can understand, Your Honor. Thank you.
Nice try, though.
Your Honor, no objection, but I do want to inquire about mine.
Oh, boy. Probable cause conference, April 10th, 2025, 9 a.m. Yes, Esteban.
Your Honor, so Ms. Boss, as the court is likely aware of the nature of the case, has a longstanding history with, I think, multiple substances, including alcohol. One of these is an OWI case. I think it's her. As one of these counts relates to the.
No, I don't.
Yeah.
I don't have an OWI.
It isn't. I'm sorry. One of these counts relates to the removal of a scram tether for such a case. I am inquiring if she is currently on an order. I saw that when she was arraigned on these cases, that I didn't see a community corrections order for her. So given the nature, I think, of the charge, I want to make sure she says it.
Ma'am, are you on a scram tether?
I was on a scram tether and I had, and a long time ago, and something I thought it was in the cases with what we are going through now. It was a part of the bond too. I bonded out on the cases.
Okay, but are you on a scram tether right now?
No, I'm not on any kind of tether.
I believe that is correct, Your Honor, that she is not on a scram tether or on the order to be on a scram tether. My understanding.
Okay, so how does somebody get out for tampering with the device and then not get put back on the device if that were?
So that was on.
I'm sorry for being too logical. Yeah, go ahead.
So that was for another case that she was on probation for in circuit court. Then allegedly something happened with that scram tether, which then the charge initiated. She has been on bond in both these cases for some time, previously referred for competency, was at a forensic center. It's found incompetent but restorable, has been restored. It's now a finding of competency. That being said, I don't believe she was ever under any order in either of these cases, to my knowledge, to be on a scram tether. And none of the charges in either of these cases are an OWI.
So, but
Yeah, that don't make sense. I did a year in the county jail. I got my tether cut off. And then I did 365 days, turned around, did another 6 months. And then they pulled up charges on me for tampering with my tampering device. But me and my lawyer and the safe house with the other judge. I think it was non-prejudice to come back at me with the tether tampering. So all of a sudden,
I see.
they just
Okay. I got it. I'm not going to change anything. I'm just going to leave it where it is because I see the dates, and so bond will continue.
Thank you, Your Honor.
what was the date, Your Honor?
Yes, ma'am.
What was the date again? April what? 9th
10th.
or 10th?
April 10th,
9 o'clock.
2 weeks from today.
Okay, thank you, sir.
Thank
Thank you,
you.
Your Honor.
Thank you, Ms. Boss. We'll be in touch again.
Okay, thank you.
Court calls the cases of Court calls the case People versus Jeffrey Stoops.
Then on behalf of the people, Your Honor.
The public defender had to speak with him on behalf of Mr. Stoops in the case ending in 1740.
Your name, sir?
Good morning, Mike. Jeffrey Allen Stoops.
You're requesting an adjournment.
I am, and I do believe Mr. Drugas did state to me he was requesting an adjournment in my case, or in his case as well. Mr. Stoops has been referred in my case to the 14B Recovery Court. I've been in contact with Mr. Reyes down there. He has not yet been down to jail to screen Mr. Stoops, but he states he is going to. I believe that'll be done sometime early next week. So I'm just requesting a 2-week adjournment of my case.
I have the written form. Where's Mr. Drukas?
He's right in the hallway.
You did say he was going to adjourn it at all.
Yeah, I know, but I have his client. I need the attorney. I mean, hey. Mr. Drukas, you're requesting an adjournment also on Mr. Stoops? Yes. All right. Yes. Hold on one moment. So how much time? There's a referral that has gone over to 14B. I presume you're tagging along with that. So where is it in that process?
I would just ask for 2 to 3 weeks, Your Honor. Mr. Reyes hasn't met with Mr. Stoops yet, but said that it's on soon. So I don't know for sure if he had been answered within 2 weeks, but I would ask for 2 to 3 weeks.
All right. Why don't we do the April 17th,
Thank you, Your Honor.
2025, 9 a.m. Yes, as to bond.
Your Honor, it's come to our attention that he has made 51 calls since his arraignment to the victims. He's been calling his phone when it is the victim that answers. In talking, they use a code name calling her Aunt Diane, but it's the victim. So we would have concerns that he's contacting her by using his own phone number and that's his phone privileges.
With regard to that, I have anything to do with this. So,
Any response to that?
No,
You're
Your Honor,
presuming it's not on your case.
So, yes, I would.
Well, you'll be entitled to certainly file a hearing once you hear all of the calls, but at this point, I'm going to revoke the defendant's phone privileges. His bond in each of these cases will continue.
Thank you, Your Honor.
This moment right here is wild. Shouting perjury at the prosecutor almost never ends well. The judge is about to reestablish control, and trust me, he does not play around.